Now I
Thank
will
you.
introduce our Toastmaster of the day, Jan-Paul Rudbol.
Thank you very much, Penelope. You're our stand-in president of the club. You're our vice president of education, as a matter of fact, just to make sure we recognize all of those different roles. Today, we have one speaker who I will introduce later, but let's first ask our timer to share with us how she is going to indicate time. Our timer is Eddie Bates. Eddie, you're muted.
Look, I get to do that all over again. That was practice. All right. Thank you. Thank you. Thank you, Paul. Good evening, Toastmasters, guests, friends. I am so excited to see everybody here at the Sunday Forum. As a timer, I will be the I'm sorry, let me start over. I will be the timer for Miss Fashika this evening, who will be giving us a lesson, and I will be showing, when she told me this will be an easy job for me this evening, at the 45-minute mark for Miss Fashika, I will be showing her this green marker. And then she will know what to do from there. And when you guys see that, just get ready, because she's getting ready to take us on a ride, okay? Other than that, just look out. If she goes beyond that, I will show the yellow card to let her know she's getting close to her time. And then I will show the red card if she goes beyond that time. And that's all I have to do this evening. So hold your thumbs up and hope I do it well. Back to you, Mr. Toastmaster.
Thank you very much, Eddie. I'm sure you will do that part well. And it's important. But my pleasure is now to introduce our very special guest, a professional registered parliamentarian, professional presiding officer, more than 25 years of experience. But that's not all. She can really explain things to people who do not have PRP behind their name. And that is why I'm so honored to welcome Fashika Willis-McClelland, PRP, again to our wonderful stage here. Looking forward to listening to what she means by govern yourself accordingly, understanding governing documents. Fashika, the virtual stage is yours.
Thank you so much, and good evening or afternoon, virtual parliamentarians. It is always a great pleasure to be with you, and thank you for inviting me back. And as stated, I do have another workshop for you this evening that I hope you will find interesting. It is called Govern Yourself Accordingly. So let me tell you where the title comes from, because that's where I always start. Govern yourself accordingly means. So now, I hear it most commonly when I am at church. Oftentimes at the end of church, one of the mothers of the church or one of the other pastor's assistants of the church will come up and give a few announcements. They will remind you of what items are getting ready to come up. But most importantly, they're going to remind you of some of the rules of the church that maybe some members maybe have forgotten about. And so they'll remind you of these few items. And then at the end of that, they will tell you to govern yourself accordingly. All right, that's a nice way of them telling you to get it together. Do what the church asks you to do. And it simply means to take appropriate action or behave in an appropriate manner as it relates to the rules that govern the organization that you're associated with. And you may remember from one of the previous workshops that I did for you, I said to you that the only way to preserve the assembly's right to act freely is for the assembly to impose rules on the members on how they would like or expect for the members to behave in accordance with the assembly. So that brings us to govern yourself accordingly. And we will be talking about governing documents and bylaws. So first we'll talk about understanding the 7 categories of rules that govern all of our organizations. Then we're going to talk specifically about bylaws, because in my opinion, your bylaws are the most important document that you have in your organization. So we'll talk about the governance power of your bylaws. Then we're going to talk about your bylaws as they relate to the organization and what the organization's responsibility to the bylaws are. Then we're going to talk about what the officer's responsibilities to the bylaws are. And then finally, we'll end by talking about what the members' responsibilities to the bylaws are. So let's go ahead and jump right in. Remember, if you have any questions, feel free to raise your virtual hand. And if you see any questions, somebody just stop me and I'm happy to answer questions as I go through the workshop. So let's talk about the rules that govern our organization. There's an order of rank to these rules. I think I've mentioned to you before, but as we go through, you're going to see that I have citations on all of my pages. And those citations are in Robert's Rules of Order. I'm telling you where to find the information that I'm talking to you about. And you'll notice that this first slide will cover 21 paragraphs in section 2, but believe me, it won't take me that long. So the rules that govern our organization, there's 7 categories of those rules, and there is an order of rank to those rules. Oftentimes in the organizations that we are a member of, we will find that we have rules that are in conflict with one another. And when you find yourself in that situation, what you want to first do is determine which category each of the rules falls into. And then based on the category, you will then resort to the order of rank for those rules. And the category that is higher in rank is the rule that will prevail. So first in the order of rank, and I believe I've talked to you about this slide before, so just humor me. Highest in the order of rank and the rules that govern your organization are the local, state, and federal laws. I'm not a lawyer. This is not legal advice. But I think it goes without saying that your organization should obey the law, at least the just ones anyway. Now, this is particularly important for you if you are an officer, especially if being an officer also makes you a member of the board of directors, because there are laws on the books in all states that that relate to what you must do and how you must behave when you serve on a board of directors. Chief among them, the most important thing to understand is that the law says that if you serve on a board of directors, then you are personally, legally responsible for 100% of the governance in your organization. That means it's your responsibility to make sure that your organization follows all 7 categories of the rules that we're getting ready to discuss on this slide. Now, I have a quick, interesting story. I think most of you know that I am a member of a sorority. And once before, we had one of the former international presidents of our sorority come and talk to our chapter here in Dallas about a few things that we wanted to talk to her about. And while talking to her, we learned that she had served on the sorority's board of directors for 16 years straight, right? And it was as a result of the various positions that she held within the sorority. So she was on the board for 16 years straight. And as a result of her 16 years serving on the board of directors of our sorority, she was personally sued 11 times. Why? Because she's on the board of directors. And when you are on the board, you are personally, legally responsible for 100% of the governance according to the law. And so as a result, every time the sorority got sued, she was personally also sued as a member of the board of directors. So that is a cautionary tale for those of you who serve on boards of directors. You can be sued. Now, whether or not you're found liable is a totally different question between you and a lawyer. But it's important to understand that, as we like to say in our sorority, when you are an officer and you are on the board of directors, it is in fact a serious matter. Now, the laws are also important for those of you who may serve on school boards or city councils or other organizations that labor unions that we refer to regulated organizations, because there tend to be a lot of laws on the books as it relates to these regulated organizations and what you can and cannot do in the governance of that organization. So please take some time, whether you're an officer or a member of your organization, to understand what the laws are that govern your organization, because you can be taken to court over them. Now, next in the order of rank when it comes to the rules that govern your organization is your organization's charter, also known as Articles of Incorporation, also known as Certificate of Incorporation. This is the legal instrument that creates your organization. This legal instrument is typically issued to you by a state or federal entity, depending on where your organization was established. And then also, if you're in an organization where there is a parent organization with a subordinate, what we call child organizations, then you'll note that the child organization's charter is issued to it by the parent organization. So the parent organization receives its charter from the state or federal government. The child organization receives its charter from the parent organization. What's important to understand about your charter or your articles of incorporation is that whatever entity gave you your charter can take your charter away from you for habitual violations of these 7 categories of rules. So it's very important. Your charter is what establishes the organization. In fact, your charter is the organization. Your charter, that piece of paper, is the organization, and you all are the organization's members. So that piece of paper is extremely important. Whenever you go to conventions or conferences, you will notice that that charter should be present because it's one of the documents that actually allows you to be able to convene as a convention or as a conference. So your charter is a very significant document in your organization. Next in the order of rank when it comes to the rules that govern your organization are your
Fashika?
constitution. Yes, ma'am.
Can I cut in with a question?
Absolutely.
But when you say that charter should be present, or what do you mean? Is it like posted on a wall or displayed on a slide or in part of a agenda, or
Uh-huh.
what do you really mean? I'm just curious.
I've seen it a few different ways. A lot of organizations will just take a picture of it and make it present on a slide. Some organizations will bring the actual document and have it displayed. It's usually framed or something so that you can't walk up and put your fingerprints on it, but it's usually framed if they're going to have it there in person. But usually it's either there in person, mounted on like a what do you call them? An easel, or somebody will take a picture of it and put it in a slide deck and show it to you, and have it present that way. That's a
Thank
great
you.
question. Any other questions about a charter? Okay. So next in the order of rank is your organization's constitution and bylaws. For most organizations, you only have bylaws. However, in the older organizations, if your organization has been around longer than 100 years, you probably have a constitution and bylaws, or a combined document that's referred to as constitution and bylaws. Now, if you're in an organization where the constitution is separate from the bylaws, then note that the Constitution is actually higher in rank than your bylaws are. But most organizations simply have bylaws. Your bylaws, in my professional opinion, is the most important document in your organization. This is the document. Remember on the previous slide, I said the only way for your organization to act freely is for your organization to impose rules on the members of the organization. Your bylaws is the primary document for providing those rules from the organization to the members. Your bylaws are the rules written by the members of the organization for the members of the organization. That is to say, your bylaws for this organization does not govern any other organization except for your own, right? Also, I think I've told you before, I've served as an expert witness in court around things related to parliamentary procedure. And I once heard a judge say that your bylaws are the law in your organization. In fact, there are 3 main reasons why organizations get sued, and I will spare you the long list, but just know that one of the reasons members of the organization sue the organization is because they feel that there has been a breach of the organization's bylaws in some way. So it's a very serious concern, and an understanding of your organization's bylaws should actually be part of your organization's risk management strategy, because a lot of members sue their organizations over bylaws. Usually, if I'm being candid, it's because somebody lost an election and they feel some kind of way. But regardless, your bylaws is one of the most common things that will get you in court. And should you have to go to court, and I hope you never do, you will be required to produce your organization's bylaws. Next in the order of rank when it comes to the rules that govern your organization are your organization's special rules. Your special rules are rules that are parliamentary in nature. That is to say, they refer to a topic that is thoroughly discussed in Robert's Rules of Order or in your parliamentary authority. Excuse me while I lean over to grab my book. Robert's Rules of Order, newly revised at 12th edition. I hope y'all can see that. Right. So your special rules talk about a subject that is found in your parliamentary authority. However, it is special because this particular rule either contradicts or is otherwise substantively different from the way that the rule is written in Robert's Rules of Order. The example that I always give is, for instance, in Robert's Rules of Order, it says that in debate, a member may speak twice for 10 minutes each time. However, in one of the organizations that I'm in, we have a rule that says a member may speak twice, but for 2 minutes each time. That 2-minute time limit is substantively different from the 10-minute time limit that is offered in Robert's Rules of Order, thus making that particular rule in my organization a special rule, also known as Special Rule of Order. So those are your special rules. They are often found in your organization's bylaws. They're kind of embedded in there with some of the other language. Also, if your organization has a document like a policy and procedure style document, usually the policy portions of that document are akin to special rules, and the procedure part is akin to another category of rule that we will talk about later. And an organization that I'm in, we actually have a book of special rules that we refer to as the Manual of Standard Procedure. And it is a book full of our organization's special rules. And in fact, you receive a Constitution and Bylaw booklet, and you receive a Manual of Standard Procedure booklet, because those two books together make up the most significant set of rules in that organization. So your special rules are particularly important. They're oftentimes found in your bylaws, but not always. Now, next,
There's a question from Eva.
yes, ma'am, Miss Eva.
Yeah, thank you. I just have a question. Are special rules and standing rules the same, or is there a difference?
There is a difference. Your special rules are parliamentary in nature, and they are 4th in rank. Your standing rules are purely administrative in nature, and they are 6th in this order of rank. So we will be getting to those soon. But no, they're very different, very different.
Thank you.
No problem. All right, so next in the order of rank as it relates to the rules that govern your organization is your parliamentary authority. Your parliamentary authority is simply a book of rules. Now, in your organization, you can come up with copious amounts of rules on your own, right? That will typically fall under category number 3 or category number 4. You can come up with a ton of your own rules. However, when you find yourself in a situation where your own rules are silent, you will then defer to the rules as they are written in your parliamentary authority. For what I like to say is 99% of organizations, their parliamentary authority is Robert's Rules of Order, newly revised, the 12th edition. But there are several other parliamentary authorities out there. Legislative bodies typically use the Mason's Manual. The American Institute of Parliamentarians uses the standard, SIP, standard parliamentary, they're going to be terribly upset with me. I can't even think of the name of the book right now. And then there's also Demeter's Handbook is another parliamentary authority, but the most commonly used parliamentary authority by far is Robert's Rules of Order. It is 5th in the order of rank. It is simply, your parliamentary authority is simply a book of rules that you can use when your rules are silent. Now, next in the order of rank to Miss Eva.
Excuse me, Another question here
Yes,
from
ma'am.
AJ.
Yes.
Yes, my question is going back to the special rules. You mentioned that some organization have another separate binder outside of the bylaws with all these special rules. My question is it an advantage to have a separate one that the bylaws refer to, or put it right into the bylaws together? So what is the advantage of having another binder with that?
It depends on the volume of these rules that you have. If you don't have very many, then they tend to just include them as part of your bylaws. However, if you're like my organization and you have an entire set of special rules, then they typically will put it either in another book or in a policy and procedure style document for your special rules. So it really kind of comes down to the volume of special rules that you have. And even if your special rules are embedded into your bylaws, they're not going to be called special rules. They're just going to be text in your bylaws. And the way you would know them from the other text in your bylaws is one, and we're going to get to that in this presentation, there is some standard language that is included in all sets of bylaws, and then you have some non-standard language that tends to occur in bylaws. And when you come across that non-standard language in your bylaws, it's likely that you're looking at a special rule. So it
Thank
just
you.
really depends on the volume, AJ.
Thank you.
There's another question, please, from Jan Paul.
Yes, sir.
Yes, Fashika, you mentioned that sometimes people are taken to court. I assume that's a civil case and not under a federal. It's kind of the judge is then kind of like Solomon, has to decide. Has there ever been a case where a judge had an opinion about the Robert's rules, kind of these parliamentary documents, saying that it doesn't make sense, or it's vague, and therefore it's sent back basically to Robert's rules, the publishers to review and to clarify it based on that a court opinion.
Interestingly enough, the cases that I've been involved in, they were all civil. They were all civil. Now it goes without saying that if your treasurer is stealing money, you could end up in criminal court. But all of the cases that I've been involved in, they have in fact been civil. I've never seen a judge say that Robert's Rules of Order was too vague. Robert's Rules of Order is a lot of things, but vague it is not. But no, I've not ever heard a judge kind of rule against it unless there is a law that supersedes what is in Robert's Rules of Order. I've seen an organization come to court quoting what is in Robert's Rules of Order, and then the judge reminds them, okay, I understand that's what Robert's Rules of Order says. However, the law in this state says XYZ. So it's important that you know the laws in your municipality that govern your organization, and understand that the laws are higher in rank than Robert's Rules of Order. So if the law says one thing and Robert's Rules of Order says something else, please note that Robert's Rules of Order is 5th in the order of rank and the law is number 1. So and then there was an interesting case that I heard of, and this happened, I want to say 20 to 30 years ago, so I was not involved in it. There's a fine line that parliamentarians walk, especially those of us who are not lawyers. And so anyway, long story short, a group of lawyers sued a group of parliamentarians over what's known as the unauthorized practice of law. And long story short, the parliamentarians won. And the gist of the ruling on that was a simple stating of the law, or the regurgitation of the law is not considered practicing law. So for instance, if I say to you, Jan Paul, hey, you can only cross the street at a red light. You can't walk out in the middle of the street. You can only cross at a red light. That is not me. That's not considered as me practicing law, simply because I'm quoting to you what the law is. I'm quoting, quote, the simple language of the law. So so in that case, it kind of got a little interesting. But no, in the cases that I have been involved in, they've all been civil. Any other questions for me? Okay. All right, so then next in the order of rank to Miss Eva's questions is your standing rules. Your standing rules are purely administrative in nature. They have nothing to do with Robert's Rules of Order. They have nothing to do with parliamentary procedure. They are purely administrative. For instance, if you have a rule that says that you meet on the first Saturday of every month, that is a purely administrative rule. That is a standing rule. If you have a rule that says you do not accept more than $25 in cash, that is a purely administrative rule. That is a standing rule. If you have a rule that says you must raise your virtual hand to be recognized, that is a standing rule, a purely administrative rule. If you have a rule that says that you must type your name when you enter the meeting, again, purely administrative rule. The time of your meeting is an administrative rule. The location of your meeting is a purely administrative rule. Your standing rules, purely administrative. Now, what you will also notice about standing rules is if you have ever been to a conference or a convention, then the third thing you do in that convention is adopt a set of standing rules. But what parliamentarians find interesting about the standing rules that are often presented at conferences and conventions is that an overwhelming majority of them are actually parliamentary in nature, which means they would probably be more properly or more accurately described as special rules. But we're going to let them make it. Don't give your president a hard time. If at the convention they refer to these as standing rules, let them keep calling them that. But next time that you're at a convention, take a quick tally of how many of those rules presented are parliamentary in nature and how many of them are actually administrative in nature. So it's a very interesting phenomenon that we see at conferences and conventions. But keep in mind, your standing rules are administrative in nature. Your special rules are parliamentary in nature. And then finally, lowest in the order of rank when it comes to the rules that govern your organization are your organization's customs, also known as traditions, also known as rituals, also known as the things that you do because you've always done them that way. Those are your custom. They are the lowest in the order of rank when it comes to the rules that govern your organization. And this represents all 7 categories of your rules. And remember what I said earlier. Should you find that in your organization you have 2 rules that are in conflict with each other, the first thing you want to do is to determine which category each of the rules falls in. And then from there, based on the category and the order of rank of that category, the one that is highest in the order of rank is the rule that will prevail in that particular situation. Also, should you have a custom in your organization that you do not particularly care for, a custom, one of the things that you do because you've always done it that way, all you have to do is point out that the custom is in violation with one of the higher ranking sets of rules, and then that custom will have to go away. Also, quick quiz for anybody who's quick on the draw and can unmute yourself. If your bylaws say one thing, but Robert's Rules of Order says something else, which rule are you going to follow?
Your
Bylaws.
bylaws. Eddie
Absolutely.
said,
If the law in your state says one thing and your parliamentary authority says something else, which rule are you going to follow?
State law.
Allah.
Absolutely. So please familiarize yourself with these. If you are an officer, remember you are personally, legally responsible for 100% of the governance of your organization, meaning it is your job to make sure your organization follows all 7 categories of these rules. So just because you are the treasurer, it does not mean that you're only responsible for the rules as it relates to the financial governance of your organization. You are responsible for 100% of the governance of your organization. If you are the secretary, you're responsible for 100% of the governance. The president, of course, responsible for 100% of the governance. Whatever position you hold that also puts you on the board of directors, you are personally, legally responsible for 100% of the governance of your organization. Going back to the example that I used earlier when I told you that one of our international presidents came to speak with us. One of the sets of years when she was on the board of directors, it was because she was what we call a regional director. And so she was the regional director of one region on one side of the country. And something terrible happened in a region that was on the other side of the country. So not even the region that she was responsible for. However, when that terrible thing happened in that region that was on the other side of the country, she still got sued. Why? Because she's not just responsible for the governance of the region that she is the director of. She is personally, legally responsible for 100% of the governance. Please take it seriously when you are in an officer role. Please take it seriously when you serve on a board of directors. Some organizations refer to it as an executive committee, whatever you may call it. That governing body, please take it seriously and familiarize yourself with all of the rules associated and that govern your organization, because it is, in fact, a serious matter when you take on these positions. I'm not discouraging anybody from running for an officer position, because it is my opinion that everyone should endeavor to serve in an officer role at some point during your time in your organization. However, it is important that you understand that you must familiarize yourself with these 7 categories of rules and then do what you can to make sure that your organization is following all 7 categories of rules. Now, there was something that I mentioned earlier when I was talking about a charter and I was talking about a parent organization.
You've got a bunch of questions.
Oh, okay. Yes,
Lobbing your way
let's go.
before you go on. So
No, come on.
AJ, your hand was up first.
Yes, I'm concerned about board of directors are responsible and you're legally and responsible. Now, supposing the board votes for something that I think might be illegal or is, can I vote against it and public state that I'm not part of this thing? And let's say that I'm in an organization that voted to rob a bank. Can I say I don't want to do that? Will that get me out of jail? I mean, I have to publicly state it somewhere. I don't want to be part of this. I want to resign or whatever.
You definitely would want to vote against robbing the bank. And even if the motion to rob a bank passed, there's nothing wrong with saying, hey, I just want to state for the record that I'm absolutely against it. Now, will you stating for the record that you're against it stop you from actually being sued? Maybe, maybe not. You'd have to talk to a lawyer about that. But if somebody chooses to sue your organization over the fact that your organization decided to rob a bank, you're probably going to be listed in that case too, even if you voted against it. Any other questions?
Yes, I had a question about your special rules and standing rules in
Yes,
your
ma'am.
example. I know that Toastmasters, certainly on the district level, and I'm going to have to go back now and look at the international level, we do very often have that one sheet of paper that's called the let's do it this way tonight, or the standing rules, or the special rules, or the whatever. But it's one sheet of paper that has an entire variety of different regulations in it. So the titling of it is not necessarily accurate. In fact, I believe, if I look back, I believe it is often very inaccurate. In that case of precedence, would it depend upon whether the rule would actually should have been a special rule or actually should have been a standing rule in terms of its precedence? In other words, if it's called a standing rule, but it really is a special rule, does the words matter? You said
Right.
don't get on your president's case. Well,
That's a perfect question, because regardless of what you call it, it depends. Does it meet the definition of a special rule, or does it meet the definition of a standing rule? So they could be called, kick rock rules, whatever they're called. But if they meet the definition of a special rule, then that's what it is. And if it meets the definition of a standing rule, then that is what it is. It matters not that they call the entire set standing rules. Should a situation come up and you have 2 rules that are in conflict, you would then at that point state, well, standing rule number 2 actually meets the definition of a special rule, and therefore it is higher than rank than something else that is in conflict with it, or so on and so forth. So really you're looking at whether or not it rises and meets the definition of the rule rather than what it's called.
Okay, great. Thank you.
No problem. Any other questions on these?
I have a question.
Yes, ma'am.
Hi. What about, I know it's not on the list, but what about committee rules or committee processes? If a committee puts out a deadline or process and our bylaws are silent, can they actually enforce that deadline? For example, if the nominating committee communicates that you have to accept your nomination by a particular date, this is not in our bylaws. Can they enforce that deadline, or is it arbitrary because the bylaws are silent?
Right. So you're saying that the nominating committee, or any committee for that matter, does have the ability to create its own standing rules that are associated with that particular committee. So for instance, if the nominating committee tells you that you must turn in your packet by January 15th, you have to turn it in by January 15th, right? Because that is the nominating committee's rules. If the nominating committee says that you can only give a 2-minute speech and you cannot use any technology, no, you cannot use any music, and you cannot use any props, that is the nominating committee coming up with some standing rules as it relates to the nominating and the campaigning and electioneering process. And they do have the ability to set those rules within the committee.
So is that a formalized thing, or is it just as if the committee says this is the date, this is the due date, does that make it a rule in and of itself?
Particularly when you're talking about a nominating committee, if they have those kind of rules, they should share them before the nominating process opens. So before packets are able to be submitted, they should share with you what those rules are. Otherwise, how you could be breaking the rules and not knowing them if they don't tell you what they are. The only way you would be able to challenge the nominating committee's rules is, one, if you're on the nominating committee, because those rules would have been voted on in that committee, or you would have to go over the nominating committee's head to your board of directors and say, well, I have a problem with this particular committee rule because it seems unfair because of this, that, and the other. But yes, committees do have the right to establish their own standing rules, and they could affect the larger assembly depending on which committee it is. But in particular, the nominating committee is known for having copious standing rules.
Okay, thank you.
No problem. Any other questions for me on this? Okay. All right, so I talked earlier briefly about a parent organization and what I called a child organization. A child organization is really just a subordinate organization. So here is an example. I'm using my sorority as an example of what this could look like. It's different from organization to organization if you have these quote unquote parent to child relationships, but I just want to show you an example of what it would look like. So you would have the parent organization at the top, and my particular experience, the parent organization would be the sorority itself. The name of the sorority is the parent organization, and that parent organization received its charter, in my case, from Washington, D.C., because that's where we were incorporated, in Washington, D.C. Now, the parent organization has a board of directors. Remember, I told you that lady was on it for 16 years in a row. It has its board of directors, and the parent organization has its own assembly, its parent assembly. Now, our organization is broken into geographical regions, and we have, quote, regional conferences. And so those regional conferences are regional portions of the parent organization's assembly. Now, the full parent assembly only meets biennially in the summer. That is to say, we only meet every other year in the summer. However, the regional subsets of the parent assembly meet every year, right? And so that's how that works. And then also we have, these would be your child organizations, if you will. Your child organization will also have its board of directors, which it would be, down below here. I don't think y'all can see my mouse, but it would be below there. And the child organization would have its assembly. Now, what's important to understand when you are in a parent child style organization is that both the parent organization and the child organization will have these 7 categories of rules. And it's important to note that all of the parent organization's rules outrank all of the child organization's rule. It's just like a parent-child relationship in your house, right? Any rule that the parent in your household establishes, the child must adhere to them if they want to remain in that house, right? And so it's the same way. So your parent organization will have these 7 categories of rules. The child organization will have their 7 categories and these same rules, their versions of these same categories of rules. But it's important to understand that the child organization's rules cannot conflict with the parent organization's rules. There are some instances where they can be slightly different as long as they are not in conflict with, but there is no circumstance under which a child organization's rules can be in conflict with the parent organization's rules. And if that happens, if you're in the child organization, what we call a chapter in our sorority, if you're in a chapter and your chapter's rules are in conflict with the sorority's rules, the sorority will more than likely pull your charter, meaning your chapter no longer exists. Why? Because you are habitually violating the parent organization's rules by having rules of your own that conflict with them, right? And so it's particularly important that if you are in an organization that has this structure or a structure similar to it, it's important that you understand very clearly that the parent organization's rules are higher and are, I don't want to say superior, but they're higher in rank. They are, put it like this, your child organization's rules are subordinate to all of the rules from your parent organization. It is extremely important that you understand that, because I've seen a lot of child organizations get in trouble, get a little sideways with the parent organization because they had rules that were in conflict with the parent organization's rules. So please make note of that if that is a situation that you are in any of the organizations that you are a member of. All right, talking a little bit more about what we call parent organization versus child.
You have more before you go.
Oh.
Before you go on, AJ has another question.
Yes,
Yeah,
AJ.
Yes, concerning parent and child relation, I mean, can a child organization chapter eventually goes up, be mature, and be equal rank with a parent, and then they'll have you sort of like independent if it's written that way in the organization?
You said, can a child organization eventually become the parent organization? Is that what you're asking?
No, I mean equal organization like the parent. They're like a different
Oh,
chapter.
can a child organization eventually become the equal of the parent? In order for that to happen, the child organization would have to break away, become independent, create its own organization, and do so. For instance, no, I'm not even going there. The people in my sorority know what story I was getting ready to tell. I'm not going there. But anyway, but no, if for whatever reason a child organization decides to break away, become independent, and create its own organization, then in that sense, I guess you could have kind of a parallel, separate and other parent organization. But we are talking about creating an other organization. You would not still fall under the original parent organization.
Right, thank you.
Man, it's a good story that goes along with it, but I'm not going there, D9. I'm not going there. Not this time. I'm gonna let y'all make it. I'm not going there. But man, I want to. Okay. Parent organization versus child organization. Remember, if you're in one of these organizations, the child organization's charter was issued to it by the parent organization, which means the parent organization can take your charter away. And when that happens, your chapter or your unit no longer exists until the parents say it can exist again. So it's extremely important that you understand that you receive your rights to act or be a part of that organization from the parent itself through the charter. Remember, the charter is the same as an article of incorporation or a certificate of incorporation. Remember, it's either issued by a state or federal entity at the parent level. It's typically drafted by an attorney, in accordance with a legal procedures, meaning if you want to change something that is in your charter, you're going to have to get a lawyer involved in order to do that. That's not something you can simply vote to make changes to. That's a legal instrument, and you would have to go through a legal process to get that changed. The charter supersedes any rules that a subordinate body may adopt. So remember, your charter was second in the order of rank when it comes to the rules that govern your organization. All the rules below that you actually have the ability to make changes to, you can't change the law, you can't change your charter, but all those other 5 categories of rules, your charter supersedes all of that. Typically, your charter is going to tell you what your name is, maybe the objective of your organization, and sometimes the location or the area that you serve, right? Those type of very, very high level things tend to be found in your charter. And the other rules that you create are subordinate to what is found in your charter. And then finally, and this is the important part, I should have put this in all bold and all capital letters. The charter carries with it the requirement that a subordinate unit, i.e. a child organization, adopt no rules that conflict with those of the grantor, i.e. the parent organization. Remember, whoever gave you your charter can take it from you, right? So it's extremely important for those of you who are in organizations that have this type of relationship that you understand that you cannot create rules that are in conflict with the rules of the entity that gave you your charter. You can't. It will get you in a lot of trouble and a lot of headache, and it's a mess. So please keep that in mind as you're creating rules in your organization. All right, so now let's talk more specifically about bylaws. The rest of this is going to be about bylaws. So bylaws, your bylaws determine a few things. First and foremost, it determines the structure of your organization, how often you're going to meet, who can be a member, who are the officers, what are the duties of those officers, how do you amend your bylaws. Your bylaws determine the structure of your organization. Your bylaws also determine and detail for you the rights of the participants in the structure. Now, the participants in the structure means members, right? So the rights of members tend to be found within your bylaws, right? It'll tell you, whether or not you have to pay dues, whether or not you're subject to assessments, how the nominating process may work, and how to deal with the nominating committee that another member asked me about. It determines the rights of the participants in the structure. So the bylaws determine the structure, and then they also determine your rights within that structure. And your bylaws determine the framework within which your rights can be exercised. So your bylaws determine the structure, they determine your rights within the structure, and your bylaws determine the framework within which you can exercise your rights. So in short, your bylaws determine governance of your organization. These 3 things together are the governance, what we mean when we talk about the governance of an organization. So your bylaws determine the structure, determine your rights, and determine how you can exercise your rights within the structure. That is why this document is so incredibly important, because these 3 things, the governance, are the most important thing for your organization to determine how your organization will prosper, how good your organization will be at performing its work, how well your organization will live up to its objective or its missions. All of these are determined by your governance, and all of these pieces of your governance are found primarily in your organization's bylaws. So please, please, please make sure you understand what's in your bylaws. Now, speaking of understanding what's going on in your bylaws, here are 9 questions that we as parliamentarians, or just as members of organizations that we serve in, either receive all the time, or questions that we ask all of the time. These are all why questions. First question is, why do we only meet once a month or once a year or once a quarter? Next question is, why do we have to pay dues or assessments, or why do we have to pay so much in dues and assessments? Next question is, why do we have so many officers? Why do we have so few officers? Next question is, why is our quorum so large? Or in some cases, why is it so small? Another question, why can't I attend executive board meetings? I don't know what people think goes on in board meetings, but they tend to ask the question very often, why can't I attend the board meetings? Next question, why does the president or the board have so much power? Next question, why are we required to use Robert's Rules of Order newly revised? These are the questions, some of the questions that I receive or I hear the most. And the answer to all 9 of these questions is exactly the same. The answer to this why is simply because your bylaws say so, right? So the answer to all 9 of these questions is because your bylaws say so. So when you get these questions, tell them, please go read your bylaws, because that is why. Now, again, regarding your bylaws, these are the rules by your organization for your organization. So you get to help create these rules. You must follow these rules. You get to amend these rules, and it's your responsibility to know what these rules are. Your bylaws, remember what I told you about the judge that I happened to be in court with? The judge said it is a social contract, is what he said, between the members of the organization. He said it's a social contract between members, so member to member, and it's also a social contract member to organization, right? So it is a social contract between the members of your organization, and the rules in your bylaw must be followed, or you literally have no organization. You are called an organization because it is organized, right? It is what it sounds like. You're called an organization because of how it is organized. But if you choose, or you all choose not to follow the rules, then you are no longer organized, and therefore can no longer call yourself an organization, right? So it's extremely important, again, that you understand your bylaws and you understand how they relate to your rights as a member in that organization. Any questions for me?
Yes, there seems to be. Jan Paul has a question.
Yes, sir.
Yes, you might still touch on this later, or maybe on your next slide, but bylaws must be there at the beginning. So who votes on it at the beginning? And then who votes on it when you want to change it? And are there specific bylaws or subsets of the bylaws that require a different quorum or a different majority to vote on to change them?
So before your organization has bylaws, it's like a mass meeting. And there are some rules and some provisions that are presented. And the very first time that you vote on bylaws, meaning before this vote, no bylaws exist. That particular vote is by a majority vote. But then going forward, should you want to make changes to the bylaws that already exist, that vote typically requires a 2/3 vote with notice in most organizations. There are some organizations that have some variations of the voting threshold that is required in order to amend your bylaws. Now, a certain subset of bylaws that require a different number. I've never experienced an organization that had a subset of its bylaws that had a different set of rules that were set in place on how to make changes to that subset. Your bylaws are one living, breathing document. So typically, the rules on how to make changes to them are the same across the board. Now, I do not have every client in this. I do not have every organization in the country as a client of mine. So it's not to say that that does not happen, just to say that I have never seen that happen. So usually, because there's an article in your bylaws, and I think I'm going to get to that in an upcoming slide. There's an article in your bylaws called amendments. And that article will explain to you exactly how you can amend the bylaws, the exact process that you must follow to the letter in order to make changes to your bylaws. So I've never seen a case in which there was a subset of the bylaws that could be changed by a different quorum requirement or a different voting requirement than what is stated in the bylaws itself. So I've never seen it. Doesn't mean that it can't exist, just that I have never seen it. All right, so now, as promised, let's talk about bylaws and organizations, and more specifically, let's talk about the organization's responsibility as it relates to the bylaws. Now, in a previous workshop that I did for you, we talked about the organization's rights as compared to individual members' rights. So for this conversation, let's talk again about the organization's rights. You're going to notice here that in my citing of this information, you see Roman numerals as opposed to an actual number. Well, not to say because Roman numerals are an actual number, but you know what I mean. You see Roman numerals instead of a number. That is because this information is found in the forward. So before the pages start to be numbered, there are Roman numerals, and that is where you'll find this information. That is why there are Roman numerals there. I didn't just switch up the format on you. That's why it appears that way. But let's talk about the organization's rights real quick. So the organization as a whole, remember, you have rights. One of the rights of the organization is that the organization has the right to enact its own rules. You know that. We've talked about that. We've talked about 7 categories of rules. 5 of those categories, the organization gets to make up for itself, right? So the organization gets to enact its own rules. The organization also has the right to choose its own leadership, which you do by way of elections. The organization has the right to delegate to its leadership part of its authority. So authority that would ordinarily fall under the purview of the assembly has the right to delegate that to the people that they put in leadership. Now, you've seen bylaws before in the article titled officers. Each officer has like a little job description there. That job description represents authority that would normally fall under the purview of the assembly. However, the assembly has delegated that to that particular officer. And then finally, just like the assembly has the right to delegate authority to those that they put in leadership, the organization has the right to take that authority back from those people that they put in leadership. That is to say, they have the right to retain control over any of its business that it wants, right? So these are the rights of the organizations. So now, what is the organization's responsibility as it relates to the bylaws? It is the organization's responsibility to ensure that all members have access to a copy of your bylaws, whether that means they're going to mail everybody a set of bylaws, whether that means that they're going to put it on the website under the membership page so you can go in and download it yourself. But whatever it is the organization's responsibility to make sure that every member has access to the bylaws. That is the organization's responsibility. Notice I said it's the organization's responsibility to make sure you have access to the bylaws. Notice I did not say that it is the organization's responsibility to teach you what is in the bylaws. That is somebody else's responsibility, and we'll get to that later. However, it is important to understand that it is the organization's responsibility to make sure every member has access to the bylaws of that organization. And then in those bylaws, you're going to see several articles. Again, these are the rules for the organization, by the organization, on how the organization will be governed. It's important to understand, as John Paul and I were discussing, that whatever bylaws an organization will have must be voted on by the members. The members get to choose what is in the bylaws by way of proposing amendments and then having them voted on. Your bylaws that must be clear. They must be easy to understand. They must be transparent. They must be well organized. They must be easy for all members to use and understand, because if your bylaws are overly complicated or very convoluted, then that means that they are easily bypassed or easily violated. You can find a loophole around things because it's either not clear, not transparent, not well organized, some of the issues that you find oftentimes with bylaws. And Robert's Rules of Order, we're going into this is going to answer another question we just talked about. Robert's Rules of Order outlines 9 articles that you must have in your bylaws. Now, you can have more than these 9 that we're getting ready to talk about, but you should never have less than the 9 that we're getting ready to talk about. Every parliamentarian, including every virtual parliamentarian under the sound of my voice today, should know the 9 required bylaw articles. And in order to memorize these bylaw articles, my unit has come up with a mnemonic device that is No Mom Expects CPA. I know it doesn't make a whole lot of sense, but once you say it out loud 3 or 4 times, it will enable you to memorize it. No Mom Expects CPA. Now, you're going to pay special attention to the letters that are capitalized and bolded, because those are the letters on the mnemonic device that are associated with the actual 9 article that we're going to discuss. No Mom Expects CPA. No Mom Expects CPA. Here it is again. No Mom Expects CPA. Let me see if I can use my annotating tool so you can see what I'm talking about. Right here. So you see this? No Mom Expects CPA, right? So that's that. Now I got to figure out how to clear this stuff off. Wonderful. Okay. So now the N in no stands for an article, a bylaw article, usually the very first one in your bylaws, titled name. This is where you will find the actual name of your organization will be in the article titled name. Go figure, right? The O in no is for an article titled object. This is where you have the general mission or the purpose of your organization will be stated in this particular article. The first M in mom stands for an article titled members. This tells you the class of members, the eligibility of membership, also any fees or dues associated with your membership, the rights of members in the organization, and also this article very often talks about any disciplinary actions that are allowed to be taken against members of the organizations. The O in mom stands for an article titled officers. This is the article that lists for you what the officers are in your organization. The order that the officers are listed in your bylaws denotes the order of rank of the officers in your organization. Now, this doesn't matter in most organizations, but if you're in an organization that prides yourself on protocol, then the order of rank of your officers matters for things like taking pictures and who sits where and things of that nature. So the order that they are listed denotes the order of rank of those officers. It also lists for you the duties. Remember, we talked about the duties, that one of the rights of the organization is that it can delegate authority to the people that it puts in leadership, and it can take that authority back. That authority is found in the listing of the duties under each officer's title in the bylaws. Also, this article typically tells you the term of office. This is particularly important. Does it say that the term of office is for 2 years, period? Does it say it is for 2 years and until your successor is elected? Does it say that the term is for 2 years or until your successor is elected? It does not sound like much, but the way that it is stated in your bylaws can be a big deal later on in life. We'll get to that later on in this workshop. But this particular statement in this particular article, it can become very important when it comes to some particularly contentious items. This article also, in the article titled officers, is also typically where it talks about the nominating committee. The nominating committee is the only committee that will be discussed in the article titled officers. Why? Well, first, because it is the job of the nominating committee to concern itself with the determination of a slate of officers, and The nominating committee is typically elected in the same manner that officers are elected. So the nominating committee typically, not always, but typically is listed in the article titled officers because of the job of the nominating committee. Now, the second M in MOM is for an article titled meetings. This article is going to tell you about how often you have your regular meetings. It's going to talk about your annual meetings. It'll talk about your ability to have special meetings. By the way, if your bylaws do not say that you can have special meetings, then you cannot have them. So you definitely want to go and look at that. And then also, this is the article that typically tells you what the quorum is for your regular meetings. So these are meetings of the assembly, the big meetings, right? So that is what that article is for. The E in expects, no mom expects. So that E is for executive board, also called board of directors. In some organizations, they refer to this as an executive committee instead of calling it a board. I don't know why. Actually, I do. It's a pet peeve of mine. Ask me about it when this is over and I'll tell you how I feel about it. But anyway, the E is for executive board or board of directors. This tells you the composition of the board. So you remember earlier, I told you one of the most common questions that, that I get is about people wanting to know whether or not they are entitled to attend the board of directors meetings or the EC meetings. And the answer to that question is no, you're not entitled to attend those meetings unless you are part of the composition that makes up that board. Only the people who are listed in the composition are entitled to attend those meetings. Now, the board may invite you to visit, right, may allow you to come to the meeting as a visitor, but as a visitor, you have no rights, meaning you don't get to speak, you don't get to make motions or second motions, you don't get to participate in debate, you most certainly don't get to vote. Why? Because you are a visitor, meaning you are not listed as part of the composition of that board, right? So it tells you the composition of that board. It tells you the powers of the board. One of the powers of the boards that is typically present in every bylaws that you will see reads something to this effect, that the board has the authority to make decisions on behalf of the organization in between regular meetings of the organization's assembly. That particular statement is the power that makes a board deliberative. We talked in one of the presentations that I did for you all months ago about the difference between what a deliberative assembly is. A deliberative assembly is the people who voluntarily associate together and they vote to make decisions on behalf of the entire organization, right? This is particularly interesting if you are in, quote, a membership organization, such as a sorority or a fraternity, right? That board gets to make decisions on behalf of the entire organization in between the national convention, right? So it's interesting, especially if the national convention only happens every 2 years. It means that board is going to make a lot of the decisions on behalf of the organization. A lot of people in those membership organizations hate that, but there really is nothing that you can do because this particular powers section of the bylaws gives them the authority to do that. In other organizations, the board is the assembly. For instance, if you serve on the board of a nonprofit organization, if you serve on the board of the Boys and Girls Clubs of America, the board is the assembly. They do all the voting, they make all the decisions. There is no body of members that they have to meet with biennially in the summer. The board is in of itself the assembly, whereas in a membership-based organization, the board is a assembly, not the only one, but it is one of two typically assemblies that are present in a membership-based organization. That's a little extra talk for you. Now, also in this article, you'll talk about how often the board meets, how many times a year or how many times a month. And it will also let you know what the quorum is for in a board meeting, right? So the quorum in the article titled meetings is the quorum for the assembly's meetings. The quorum in this particular article titled executive board is the quorum specifically for the board meetings. Now, no mom expects CPA. The C in CPA is for an article titled committees. This is going to name for you all of your standing committees. Oftentimes they are numbered, not always, but you can count them for yourself if you need to know the number. Also, it will typically talk about the manner of selection to these committees, whether you can simply sign up to serve on a committee, whether you must be appointed to the committee. That type of information is usually included in this article. It also talks to you about the duties of the committee. So just like the officers have duties that were delegated to it by the assembly, committees also have duties that are delegated to them also from the assembly. And then also this article will tell you whether or not you have the authority to have special committees. If, again, this article does not describe your ability to have special committees, then it's presumed that you cannot have them. So you want to go and look for that in your bylaws as it relates to committees. Notice that it's very seldom, but I get this question a lot about quorums for committee meetings. Yes, the quorum for your committee meeting is different from the quorum for assembly meetings. Remember, for the assemblies meetings, it specifically tells you what the quorum is. For your board meetings, it specifically tells you what the quorum is. However, typically for committees, it is typically silent on what the quorum is for a committee meeting. If your bylaws are silent on the quorum for a committee meeting, then it is understood that the quorum for your committee meeting is a majority of the committee's members will make up a quorum, unless it's otherwise stated. If there's a specific quorum for your committees, then it'll be listed here. But if it's not listed here, the quorum is a majority of the committee's members. The P in CPA is for an article titled Parliamentary Authority. It will tell you what your organization's parliamentary authority is. For most organizations, it's Robert's Rules of Order newly revised. And then finally, the A in CPA is for an article titled Amendments, and this will tell you the exact procedure for how to amend your bylaws. It will tell you what notice is required. It will tell you who you are to send that proposal to, whether you're sending it to a bylaws committee or you're sending it to the president or you're sending it to the board or whoever you're supposed to send it to. It'll tell you that. Oftentimes it'll let you know if there's a time frame within which you must submit them. Sometimes organizations have a time frame for turning it around and presenting it back out to the assembly. So you want to be particularly mindful of this article. If you are a member of the bylaws committee, it is your job to protect one of the rights of the organizations, right? The organization has the right to create its own rules, and the way they do that usually primarily is by the adoption or having bylaws. And to amend those bylaws, again, a right of the assembly, and the bylaws committee plays a very significant role in protecting the rights of the assembly to be able to control its own rules and to make changes to them if they are interested in doing so. So this is No Mom Expects CPA. The 9 bylaw articles that every organization should have in their bylaws. Remember, you can have more than these 9, but you should not have less than these 9. And they will typically be listed in this order. Now, you may have some other articles that will, kind of come in between them, but these 9 are typically in this order. And sometimes, like I said, with articles in between them about other things. Are there any questions about No Mom Expects CPA and the 9 bylaw articles that every organization should have in their bylaws? Also, shout out to 2 of my mentors, Rhonda Clark Randall, RP, and Rita Cloman, PRP. They came up with No Mom Expects CPA and taught it to me a long time ago, and I've been teaching it ever since. Any questions for me on this, Penelope?
Yes, AJ has a question.
Yes, my friend AJ.
Yes, currently I'm on an organization on bylaws, trying to revise the bylaws. And there's a lot of deficiencies, and we're in a dilemma. Because first of all, the bylaws just didn't say that we have to have notice, and they just say that we have 2 meter you read the amendment in the one meeting, and then you vote on it in the next meeting. That's defined as notice, but we didn't define on that meeting what is a quorum. And we could have 3 people and say, hey, we'll notice. Yeah, and we're going to change that. And then no quorum for the assembly to amend the bylaw. So maybe what is the suggestion now? Just so we take Robert, say it's the majority is the quorum of the membership, and then we could amend, and then we could announce it, and they'll get notice. And then the next one, if we have a quorum of a majority, then amend the bylaws to make it correct. So in the future, you can't just have the awkward and anybody can change it. Is that correct, or how should I approach it?
I'm gonna try to answer the question that I think you are asking. So your bylaws must be amended at a regular meeting or a special meeting specifically called for that purpose. So your bylaws must be amended at a regular meeting or a special meeting. In your article titled meetings, it should tell you what the quorum is for a regular meeting or a special meeting. So whatever the quorum is that's required for your regular meeting or your special meeting is the quorum that must be present when you are voting to amend your bylaws. Did I answer your question, or am I still tap dancing around it? Or is that only part?
Yeah, I understand that. Yeah, you can have you must have a quorum to have an actual meeting. It's just that our bylaws is deficient. I try and look for it. Nowhere in the says what is the quorum of this regular meeting. We've been meeting and we got members coming, but should, in that case, if it's silent, should we just say go by Roberts, a quorum is more than half of the assembly members?
So you're saying that in the article titled meetings or nowhere else in your bylaws does it actually state what the quorum is for? I mean, yeah, that's problematic. That is certainly problematic. In the meantime, I would go with the default to Roberts with using a majority of its members, but that would probably be one of the first bylaw amendments that I would propose, would be to put in place a quorum for regular meetings or for the meetings of the assembly. So wow, yeah, that should definitely be a bylaw amendment that you would want to
Right.
consider as putting in a quorum into your bylaws for the assembly's meetings, because I can see
That's
how
what
that could cause some issues down the line.
right. Thank you. That's all too.
Yeah,
No problem.
next we have Atul.
Hello, my friend. How are you?
I'm good, thanks, Fashika. No, I was going to try to help AJ, but you covered everything I was going to say. So
What were you going to say? You say it better than me. You say it.
Well, you're right. If AJ's bylaws are silent on, don't mention what a quorum is, then you go to Roberts, and Roberts is a majority of the body that's meeting. The only other thing and yes, the meeting that you give notice has to be a meeting where there's quorum. If it doesn't have quorum, you can't officially give notice at that meeting.
Right.
And same with the meeting where you make the decision. So you covered both those points.
Awesome. Awesome. Y'all, don't let me forget to tell y'all an awesome story about Atul serving as a presiding officer. I'll do it at the end because I don't want to run out of time, but he is awesome. He's one of my favorite parliamentarians and my new best friend. All right, so now
There's another question
oh,
here that's
yes, okay.
specifically related to a Toastmaster situation from
Okay.
Jenny.
It's actually tied in with AJ's question, because some of the clubs, which are considered a separate legal entity from Toastmasters International, which gave them the charter, want to change the definition of a quorum, which is in the Toastmasters International governing docs, in order to make it easier to have valid decisions. And based upon what you said, it seems like since we got the charter from TI, we have to use TI's definition of a quorum and cannot change it to be less than a majority. which is more than half. So I think you solved, I think you addressed that, unless my understanding of
It
what you said is different. Go
It
ahead.
depends on the structure of that organization. For instance, I told you I'm in an organization that has a parent organization and has child organizations. The quorum that is listed in the international constitution and bylaws, that quorum is for when the parent assembly meets. It only applies to the parent assemblies. Each child organization has its own bylaws and determines its own quorum as it relates to the child organization's assembly, right? So the parent body has a quorum for its assemblies meetings, and the child organization has a quorum for its assemblies meetings in the organization that I am in. I would assume, and you know what happens when you assume, that you would have the same ability in your organization, assuming it is structured similarly to the example that I showed you earlier when we were talking about parent organizations and child organizations. So you may want to ask, if you have an international parliamentarian or a national parliamentarian or whatever you would call that person, to confirm that the quorum listed in the parent organization's bylaws is for the parent organization's assembly, right? The child organization's bylaws would define for you what the quorum is for the child organization's assembly, right? So you may want to get some clarity there, because otherwise, I don't think there would be an issue, at least not in my organization. There's not an issue with the fact that my quorum, the quorum in my chapter, is different from the quorum that's necessary from in the parent organization. One, my chapter is not nearly as large as the parent organization, although it is rather large. But you know, we do have two different quorums, but it's because we're at two different levels, and each child organization determines its quorum for itself.
Right, except that in our government, so I agree with everything that you said. That totally makes sense. But in the governing docs, they do also have the club constitution define the quorum to match a majority of more than half. So some
Oh,
people are thinking, well, clubs can make it 10%, right, to make it easier or something like that, some bigger
oh,
number.
okay.
And in addition, uh, every member of Toastmasters signs a membership agreement to abide by the governing docs and its policies and protocols, which I don't know if that supersedes, because it's a fuzzy line where you've got the parent organization, the child, that are legally separate entities, but you still have to follow the parent because they gave you the charter and they made you sign these contracts, and then they put these clauses in there. But then again, sometimes the governing docs were written without registered parliamentarians and experts like yourselves who understand the intent behind it, where it was to empower the members to have their voice heard so that they can be included in democratic decision making, so that they can support the organizations more effectively and the decisions that they make together for retention and sustainability. It seems like lately, because the leadership team may or may not have this understanding or your expertise on parliamentary procedure or the guidance, that it's been written more to make things efficient, to top down steamroll and make it timely, but not have as many voices heard, not have discussions during the general meetings, that somehow that intent has been lost to protect the parent organization and not so much the child organizations, if that makes sense.
It does. And so if I heard you correctly, the parent organization's bylaws also dictate what the quorum is for the child organization. So in that case, the only way that the child organization could even have the possibility to change what their quorum is that they must first submit a bylaw amendment to the parent organization's rules, either to strike that language altogether that, you know, dictates what the child organization's quorum is, or to just make a change to it, or, you know, strike out majority and insert, I don't know, 25% or something to that effect. So it seemed like that would probably be the better way to go, to try to submit a proposal to the parent organization's bylaws to change what a club's quorum can be.
Fashika, we've got
And just one more
questions are
comment.
stacking up
Okay.
here. I'm
Oh,
sorry.
okay.
Just one more comment before I know Atul's hand went up. It's confusing because in part, not only does the governing docs have the club constitution's definition, but then it has a section called Policy 1.0, whereby section 3C, where all its handbooks are considered protocols. So the club constitution also states the definition of a quorum of a majority. So the problem is the average member doesn't know where to find all this information. It's not located in one central place, or it's scattered to refer to all these other sub protocols and protocols. So how is any member supposed to really know how an organization operates when it's scattered to redirect you to all these things that are written in handbooks, and then websites and all these other things? And then it's not updated efficiently or timely as the needs of its members change. So I'm done.
Absolutely. That is a great question to pose from the floor of the next convention of your parent organization. Make them give you an answer to that. What's the next question?
Atul was next, I believe.
Yeah, I just had a quick peek at the TI website, and it looks like the club constitution is actually a document of Toastmasters International, and to be a club of TI, you have to accept and be bound by the club constitution that is written by TI, as well as the policies and protocols. And you can only amend the club constitution at a meeting of TI.
Mm.
And so, yeah, they've got, as Jenny was describing it, it matched what I was reading, that it's a very top down. So it sounds like the virtual parliamentarians could not change the quorum for its meeting. It would have to be the club constitution, which can only be, they'd have to propose a change to the club constitution at the TI International meeting. So it sounds like it's as Jenny was describing it, it matched what I was reading, is that it's much stricter control from the international body.
Absolutely. So, Jenny, if I were in your position, then I would submit a bylaw proposal to change the parent organization's bylaws as it relates to what they were saying about the Constitution for the child organizations, to see if you can just get that struck, to strike it out. And then in debate on your motion, you would say in the convention what you just said here about why and how restrictive it is and how confusing it is, and so on and so forth, and then encourage the other delegates who are there to vote in favor of this, because if it's affecting your organization, it's affecting all the other child organizations too. So the way you do that, submit, go to the TI's article where it tells you how to amend the bylaws. So submit one, propose one to strike that language out or to amend it. It depends on what exactly you want to do with it. And then in your rationale, say what you said. And then when you get to the convention, make sure you go to the microphone or whatever the custom is in your organization and debate in favor of your proposed amendment. But until you get a change at the international level or at the top, you're not going to be able to change what your quorum is.
We have questions are still lining up here. So the next one is Eddie. Miss Eddie,
Okay.
do you have?
Yes, thank you. Miss Fashika, I
Yes.
belong to an organization that is on a national level, a regional level, and a state level. I do a lot of things on all of those levels, but in the state level, I decided to get on the committee of amending the bylaws, because on the state level, we're only 13 members strong.
Mhm.
When we began to look at these bylaws, we noticed that the jargon on the state level, the regional level, was exactly the way the national level was. And we couldn't understand any of this stuff. It didn't pertain to us. We didn't do this stuff. And while I want to make sure we got a special committee to amend these bylaws, which included myself and two other young ladies. We went through, and us three, we started to make it more clear, clarified. We put it in plain English. We put some breakdowns in there, and now we're ready to take it back to the board. My question is, are we going against the regional or the national level by changing those bylaws to fit the 13 people in the state?
It depends on what the national organization's bylaw says, and it depends on the structure of your national organization. For instance, is the state organization part of the regional body's assembly, and then the regional organization is a part of the parents' assembly, or is the state part of the parents' assembly and the region is just so happens to be there? It depends on the structure. So you would first need to backtrack to the national organization's bylaws and governing documents to see what it says there. Is it like with TI where you can't make changes to it with that?
Oh no,
unless you come through the
you make
national
changes.
organization first.
Yeah, we can't make changes. Actually, the national has a set of bylaws, the region has a set of bylaws, and then our state level has a set of bylaws. But we were just confused as to why it sounded so much like the national for 1,200 people, and here we are, just a handful of folks, and we just thought it was massive, and it was completely, we just couldn't understand on that level.
And it's not uncommon for a child organization's bylaws to more or less regurgitate the parent organization's bylaws. I don't particularly care to see it like that because, interestingly enough, if it's already in the parent organization's bylaws, you don't necessarily need to say the exact same thing in the child organization's bylaws because you are already subject to that rule, whether it says that in your bylaws or not. That's the nature of the parent to child relationship. So it's not necessary for it to read exactly the same. If it's already covered on high, it's not necessary for you to say it again. But a lot of organizations do, just because that's what they are most comfortable with, and that's fine if that's what they choose to do. But I would say as long as your organizations, the state level organizations are not in conflict with the regional and the national organizations, for instance, there's a difference between being different and being in conflict with. So for instance, say hypothetically, you're in a parent, or your parent organization says that in all child organizations meetings, you can either wear pink or green or white, right? Now, in your state level organization, you may have a bylaw that says, well, in the state meetings, you can only wear pink or green. That's fine. It makes it different than what the national says, but you are still within the national's rules, right? However, if your state level bylaw says, well, you can wear pink or green or white or black, well, now you are outside of the parent organization's rule and you're in conflict with it. So you can be different and still not be in conflict, but you can also be different and be in conflict with it. So you want to be very careful there. And if you're going to be different, make sure you are not in conflict with any of those higher ranking rules.
Okay, thank you very much. I learned
No
a lot.
problem.
Thank you. And moving along now, Ms. Eva, you have a question.
Well, yes, I do. And I'm just for clarification for myself and maybe help for Jenny for the Toastmasters Club. What we did with our club is we have a huge membership, although many members don't show up. So it was difficult to continue with meetings and have votes and pass anything through. So what the club decided is to define what an active member is. So as long as the active member didn't show up for the last 4 weeks, they were dropped off as a active member. And that's how we solved the problem of not having enough membership show up for the meetings. I don't know if that's a correct way of doing it, if we're doing the right thing. We think we are because we did inquire about it. So I hope we're doing the right thing. And maybe that would solve a problem for not having enough quorum. I'm not sure if that's correct or not.
Quite possibly. It depends on, does your club's definition of an active member conflict with what the international body says a member is, right? If
If
the
I could
international
cut
member,
in there on Fashika, the club has to define what an inactive member is.
Oh,
In the
sorry.
rules, it says the
interesting.
club makes the definition of what an inactive member is, and an
Oh, that's
inactive member
awesome.
is not part of your quorum. So
Perfect.
as
Thank
long
you.
as the
That's
club
perfect.
has defined it, then yes, that's the
That's
common
perfect.
way that we deal with large clubs.
You found it. Well, it sounds like you're good, Miss Eva.
Okay, thank you. So I'm good. It answers
Okay.
my question at least. Thank you so much.
Okay, and Miss Lucy, you had your hand up. I'm sorry we didn't, I'm just getting around to you now.
Oh, thank you. I had a
Hi,
question.
Lucy
Raise
Anderson.
my hand.
OMG, this is another one of my favorite parliamentarians in the world.
Hello, Fashika. Question, I was just so intrigued by something Jenny said. She said that some of the chapters or the child organizations was a separate legal entity. And in that case, I'm just curious, since they're a separate legal entity, were they sanctioned by TI? And does this separate legal entity have its own set of, does it have its own constitution and bylaws? Just a question. Don't want to rehash all of the information that has been given by that, but I was just interested in that answer. Thank you.
No, that's a good question, because I also wondered how you could have a quote independent organization fall under a parent organization. So that's interesting. Jenny, you care to answer that or clarify that, or anybody who actually may have any insight?
Each club does, when chartered, does receive and must adopt the club constitution and bylaws, and does have a separate 501c3 designation and an employer identification number unique to that club. But it is very tightly still within the Constitution, very tightly controlled by world headquarters. Whether all of that is correct or not is something that Jenny and I both struggle with.
Well, I understand that, because even in the organization I'm in, the parent organization, we're a 501c7. It has its own tax ID number. My chapter has a different tax ID number.
Right.
But it does not make us independent, right? We are still a child organization and are not considered to be independent. We have our own separate tax numbers and have to pay our own separate taxes, but we are not deemed as an independent organization. So that's interesting.
I don't think our clubs are either. I mean, we have to pay dues to the parent organization. But Jenny is waving her hands up here in the corner.
Okay, tell us about it, Miss Jenny.
And then we must move on because we are running low.
Go ahead. Okay.
So our governing docs again once define that the club is a separate legal entity. It even puts it in the club constitution that it is a separate legal entity. And then because we have to follow policy 1.0 section 3C protocol, that all these other documents are protocols. That's the confusing part. But I think the ultimate problem that I realized is, because I like to follow rules, is that if the rules were made by people who didn't understand parliamentary procedure and its intent, I'm kind of following these inconsistent rules blindly. And so I think the ultimate solution, or it partially needs somebody who's an experienced registered parliamentarian such as yourselves to guide the leadership board of directors in cleaning up the governing docs every 3 years that they're tasked to do, because I think they've been revising it based on other priorities and other parameters from a legal sense that doesn't really have the members in mind for a membership driven organization. And almost none of the board of directors, except for a few, have ever even had a registered parliamentarian certification. And not saying you need one to understand it, but I think it seems like it's the blind leading the blind by writing these rules that conflict with each other because they don't understand how to write it properly or the intent behind it. Does that make sense?
Absolutely. So here's something that I have noticed. Here, and I'm gonna be careful because there's some lawyers on here today, so I'm gonna be careful. what I have noticed just in working with clients, in organizations whose bylaws are written by lawyers, their bylaws tend to give an outsized amount of authority to the very top of the organization. And organizations whose bylaws are written and maintained by parliamentarians tend to give a lot of the authority to the members, especially if it is a membership-based organization. And so it seems to me that you are describing the same thing that I've seen too. If a lawyer writes your bylaws, they're going to give most of the power to the people at the top, just because I don't know why. I never went to law school, so I don't know why, but I've noticed that too. I don't know what to tell you how to do it, unless, you know, you can suggest that another bylaw amendment, maybe that requires your board to have a credentialed parliamentarian as part of the board or something to that effect. But I've noticed that too. Bylaws written by lawyers concentrate the power at the top, and then everything else is pushed down. Sorry to the lawyers, it's no shade. I'm just saying that's what I've noticed. All right,
Fashika, we're down to about 10 more minutes.
Oh, for the whole thing?
Yeah, it's already 20 minutes of 9. That's why I was trying to push things along here a little.
All right, well, okay, well, I'll get as much done in 10 minutes as I can. So let's go on to organizations and the officers' responsibilities as it relates to the bylaws. So again, we're starting with the rights of the organization, and what you're going to recognize, those of you who are officers, is that right number 2, number 3, and number 4 all deal with officers, right? In choosing the leadership, meaning choosing who will be officers, delegating authority to officers, and retaining control back from those officers. So as an officer, it is your responsibility to know what is in the bylaws. It is the organization's responsibility to make sure everyone has access to the bylaws. But as an officer, it is your responsibility to know what is in the bylaws. That is your responsibility as an officer. As I said, 3 of the rights of the organizations relate specifically to officers. So if anybody should know what's in the bylaws, it is an officer, because so many of the organization's rights have to do with who they choose to make an officer. So let's talk about officers in the bylaws. Ooh, high horse, about to get on my high horse, so y'all just bear with me. Officers do not have more rights than other members. What they have is more responsibility than the other members. Another way to say that is the officers serve the assembly. The assembly does not serve the officers. Come on, somebody. I feel like I'm preaching. Oftentimes, one of the biggest problems within an organization is that officers, not all, a lot of officers and a lot of boards tend to overstep their authority because they think they can. But it's important to understand officers serve the assembly. The assemblies do not serve the officers. The officers do not have more rights than the other members. They have more responsibility than the other members. Also, officers, really, I'm talking about the president, but I'll say officers. There is no executive privilege that exists. We all have the same rights. In fact, if you voluntarily ran, whether you voluntarily ran for president or not, you voluntarily gave up some of your rights. You gave up your right to make motions. You gave up your right to participate fully in debate. And it was you who limited when you could and could not vote when you decided to run for office. No, there is no executive privilege that exists unless your bylaws specifically state have a article that talks somewhere about executive privilege. But no, there is no privilege. You gave up some of your rights when you chose to run for office. So no, don't come talking to us about executive privilege. Officers, you should follow the bylaws religiously, because remember, you want to do so to mitigate risk to you. Remember, I told you about the lady in my sorority. She was on the board as an officer, 16 years, got sued 11 times. Follow the bylaws religiously to mitigate risk to you personally. Why? Because you can be sued. Soon as the organization gets sued, ask the lawyers on here, when you sue the organization, the lawyers tell you to sue the members of the board too. And the members of the board tend to be officers of that organization. Remember, I told you the judge said that your bylaws are a legally binding social contract between the members, from member to member, and between the member and the organization. So it's a lateral contract and an up and down contract. You must, if you are an officer, please follow the bylaws, look at them, know what is in them, and then follow them. And do not overstep your authority, which is one of the biggest problem 1A, most common problems. 1A, officers overstepping their authority. Problem 1B, members not thinking that the rules apply to them. All right. So 1A, officers, you are 1A. So let's go ahead and talk about 1B since we're talking about it. And let's talk about members' responsibilities to the bylaws. Again, we're going to start with the organization's rights. And you're going to notice that all of the rights of the organization involve the members. It is the members who make up the body, who make up the assembly, which means it is the members who are choosing the leadership. It is the members who are choosing to delegate authority to the people in leadership. And it is the members who can take that authority back, right? And so again, it's the organization's responsibility to make sure you have access to the bylaws. But members, it is your responsibility to teach yourself what the bylaws say. You should understand every single solitary provision in the bylaws as a member in good standing, because it is your responsibility to manage what they say. The bylaws cannot be changed unless you submit a proposal and then you vote on them as part of the body that votes. So we're going to talk about demystifying bylaws. Somebody let me know when I only have 3 minutes left. I'm talking a little faster now. Bylaw amendments are simply a particular instance of the motion to amend something previously adopted. So you're looking at making an amendment. So you're just like all other amendments, just like amendments to main motions, you're either looking to strike out words, sentences, or paragraphs. You're looking to insert or add sentences, words, or paragraphs, or you're looking to strike out and insert or substitute words, sentences, and paragraphs. So to amend your bylaws is not all that different from amending a motion. You're going to follow the same process. You're either striking, inserting, or striking and inserting. Same process, generally speaking. This is an example. In this particular example at the top, the amendment is to strike 1/3 and insert 2/3 in its place. That is, the notice is written in the form of a motion. And then here's a little chart that shows you specifically what they're trying to do. I don't know if you can see my mouse. Let me see if I can get my annotating deals back. Okay, here we go. So notice over here, we're showing you that we're striking 1/3 and we're trying to insert 2/3 in its place. And then if it's adopted, it will read at least 2/3 of the association. So it's really making a bylaw amendment and amending a motion, basically the same process, except you have to give some additional notice there. Let me get this annotation off my screen now. It's distracting. Okay, there we go. All right, let me move on. Okay, so let's talk quickly about some bylaw do's and don'ts. I promise I'm almost done, Penelope. So if you're going to govern yourself accordingly in your organization, there are some things that you must do. You must stick to the basics when you're dealing with your bylaws. Your bylaws are meant to be high-level governing issues. If your bylaws read like a policy and procedure manual, you have probably gone too far. So if you have Article 2 and then Article 2 has sections A, B, and C, and then section A, B, and C also have a section 1, 2, and 3, and then 1, 2, and 3 also have a subsection lowercase a, lowercase b, lowercase c, you have probably done too much, right? Your bylaws are meant to be the high-level governing issues for your organization. If you need to create a policy and procedure style document that goes a little deeper into the weeds, then fine, do that. But you do not want to get so deep in the weeds on your bylaws because they are meant to be for high-level governing issues. If you're going to govern yourself accordingly, then you do need to understand that you have a duty to understand each and every provision of your bylaws. Remember, your bylaws should be clear, transparent, and easy to understand. If there's something that is not clear and that is not transparent and that is not easy to understand,
So I
submit a
got.
proposal.
Motion to Sorry,
Talking to me?
hold on a sec. Sorry, folks.
Oh, okay. So do submit a proposal to clarify things that are not clear in your bylaws, because you do need to take it upon yourself to make sure you understand each and every provision of your bylaws. If you're going to govern yourself accordingly, then do follow your bylaws religiously. Remember, if you're an officer, you're personally, legally responsible for 100% of the governance in your organization. Remember, this is a social contract between members, member to member, and member to organization. Do follow your bylaws and all of your governing documents. And if you're going to govern yourself accordingly, then please do make sure your bylaws are relevant. Your bylaws are a living, breathing document. Times changes, circumstances change, and as such, your governing document should reflect those changes. I cannot tell you how many clients new clients I received during the pandemic, because so many people needed to amend their bylaws to allow for an electronic meeting when Al Gore's internet has been around longer than I have been alive. Why did you wait until 2020 to decide that you need to allow your organization to be able to have electronic meetings under certain circumstances? How did that happen? Because they did not have an eye toward keeping their bylaws relevant. This is a living, breathing document that should grow with the organization and should change with the times. Now, there are some don'ts. If you're going to govern yourself accordingly, then what you're not going to do is overload your bylaws. Remember, if you need a policy and procedure manual, then create one, but do not allow your bylaws to become a policy and procedure manual. It is for the high level governing issues. So what you're not going to do is overload your bylaws. Also, what you're not going to do when it comes to your bylaws is prohibit the future progress of your organization. Every organization has a mission or an objective, and it is your job in the organization to proceed in a way that is progressive and following or living up to the objective to your organization. So when you're creating bylaws, you should try very hard not to tie the hands of future boards. You want to think long and hard about downstream consequences, like Jenny was saying about talking about earlier, of the various provisions that you're voting for that will end up in your bylaws. You want to do everything that you can to allow, to create order and efficiency and effectiveness, but you also want to allow the organization to continue to progress forward in under the mission or the objective of the organization. Do not bound the hands of the organization. Also, if you're going to govern yourself accordingly, then what you're not going to do is allow your bylaws to get stale. You should be reviewing your bylaws. Some organizations review them annually. Some do it less frequently than that. Some are more frequently than that. I would say if you're going more than 3 years without reviewing your bylaws, at least reviewing your bylaws, you may or may not need to make any amendments, but you should at least be reviewing your bylaws regularly enough to make sure that you are keeping up with the times that you live in. Remember, this is a living, breathing document. It should not become stale. It needs to grow with the organization, and it needs to change or evolve with the times, right? You should not still be printing things on carbon copy with triplicates, right? Surely there's an electronic way to do some of this paperwork you have in your organization. So be looking for things like that as you're looking through your bylaws and considering which type of bylaw amendments you may want to put forward. In conclusion, I'm done, Penelope. In conclusion, good bylaws equal good governance. You can tell just by looking or by participating in an organization's meetings whether or not they have good bylaws. You can tell by how much drama you see in the organization, right? Organizations that have good, clear, strong bylaws have good governance and have less drama, right? That's basically what this says. It eliminates all the guessworks and the loopholes and all the other things that could be problematic against the governance and the structure of your organization. Good bylaws equals good governance. Good governance equals good work. You can tell which organizations are governed well by the type of work you see them doing out in the community, by how well they stand tall in their objective or in their mission, by how they move their mission forward. Organizations that are governed well are able to move their mission forward in a way that the world can see. And good bylaws equals good governance equals good work. Right? All these things go hand in hand. So if you have good bylaws, then you will have good governance, and it will make it easier for you to do good work, because if you're not bogged down in the back and forth and the drama related to the rules or who's following the rules and who's not, you can actually spend that time focusing on doing the work of your organization as it relates to the mission and the objectives of your organization. So please, virtual parliamentarians, review your bylaws to make sure you have good bylaws. And I promise you that will lead to good governance. And I promise you it will allow you to do good work. So please, virtual parliamentarians, govern yourselves accordingly. That is my time. I'm happy to take any remaining questions if there are any.
I'm afraid we are out of time for more questions, dearly as we love you, and I'd be glad to stay on for the next, week or two to hear it all. But let our Toastmaster close out and turn it back to me or to our president, who has now arrived.
Yes,
to hear from our guests.
Thank you very much, Penelope, for facilitating all the questions. And it is very clear that my short introduction of our wonderful speaker, next time I need to spend 5 minutes at least, because she is such a source of information. She comes across so comfortably in about every type of angle related to parliamentary procedures. As I looked at all the faces, everybody was glued to their computers just to listen and absorb and ask questions. So thank you very much, Fashika, for gracing us with your presence here, as you're so knowledgeable. You have a good audience here, and I'm sure we will find an opportunity to invite you back. Thank you very much for being here tonight.